Hello the world, hello the internet, hello fans of the Supreme Court, and of course I include myself in that particular group. We're now going to talk about the Supreme Court at work, or rather the procedures and the mechanics at work rather than the reasons it makes the decisions that it does. And we're going to start off by looking at judicial review. And judicial review is of course what the Supreme Court gets up to most of the time, and that is assessing the constitutionality of any law or action taken by the state. Now, remember Marbury versus Madison, it's an assumed right. The key thing that I want to talk about here really is what the Supreme Court has access to, or the tools that they can use. If we think about Britain, we have constitutional principles, treaties and law, statute law and common law. And along comes our judge. What can he refer to in the making of his decision, or indeed her decision? Common law, absolutely. Statute law, yes indeed. Treaties and laws of the EU, yep, not a problem. But the problem with our little judge in the UK is that they do not have access to the Constitution. They cannot use constitutional principles in the making of a decision. That's because we have a parliamentary system rather than a constitutional system. Parliament decides what the Constitution is at any given time. And so constitutional principles, we all know what they are, but unfortunately for our judge, they are out of reach and they can't be used in the making of a decision. In the Supreme Court of the United States, however, the situation is markedly different. We have the Constitution, we have federal law, we have state law, and there's our judge, and all of those are in play. In the United States, everything has to abide by the Constitution, and the Supreme Court has maneuvered itself into that position whereby it assesses the constitutionality of any particular action or indeed jurisdiction, and that's quite enough of that. So the question then becomes, well, why is judicial review so controversial? And there are four reasons. First, it's extra-constitutional. Secondly, it's anti-democratic. Thirdly, it's anti-federal. And fourth, it drags the court into politics. Now, let's explain what all of those mean in detail. First of all, as we spoke about earlier, it is extra-constitutional. There is nothing in the Supreme Court, nothing in the Constitution about judicial review. It is instead an assumed power subsequent to Marbury versus Madison 1803. Now, why is that a bad thing? Why is that controversial? Well, in the first instance, it's constitutionally dubious, we accept that, but perhaps more significantly, because it's not in the Constitution, it therefore must operate of necessity outside the system of constitutional checks and balances, which means that if the Supreme Court decides that something is unconstitutional, there is no review of that decision. There is no comeback either for the president or for the or for Congress. And of course, there's nothing you can do to a judge as well. Remember, they're stuck there for life unless they are found guilty of high crimes and misdemeanors, and that hasn't happened yet. So judicial review puts the court outside the Constitution and therefore outside the system of checks and balances. There's nothing you can do to a judge who is pissing you off, and there's nothing you can do to reverse one of their decisions. Of course, all you can do is amend the Constitution, and that's about as close as we get to a check on the judiciary. And of course, the example that we found with that is the 13th Amendment and the imposition of an income tax. But anyway, that's kind of outside the, well, it's not outside this particular question, I'm just getting distracted. But judicial review operates outside the established system of checks and balances, and therefore it is controversial. It gives rise to accusations of the imperial judiciary. Nobody can touch the judiciary. But we've just seen that they can't, that in fact they can. They struck down the income tax in, I think it was 1895. Congress went, yeah, fair enough, nothing in the Constitution about that, but we'll institute the process whereby we change the Constitution. We have the 13th Amendment. Congress can levy an income tax. So you can get around it. It's just incredibly hard work. So there we go. Why is judicial review controversial? Because it's extra-constitutional. It's also anti-democratic. Remember, these guys are not elected. They've never stood for election. They are appointed. And yet they can overrule the decisions of elected legislatures and indeed the president, all of whom have won elections. So the argument goes that it is anti-democratic, that they are striking down the policies of elected legislators, elected executives. There is a counter-argument to that. I don't really want to get into it in too much detail right now, but it's rather saying that, well, what the Supreme Court is doing is they are creating the constitutional framework within which the legislators have to operate, and therefore it's not controversial. But I don't think that's likely to come up, whereas sort of simply explaining that this is anti-democratic is something you will need to do. Penultimately, it is anti-federal. We're seeing the imposition of central authority. We're seeing 9 people in Washington deciding what the states can and cannot do. We can see that through numerous cases, and we'll discuss those particular evidence items as we go through this presentation. But it is that idea that we are seeing here with judicial review, one size fits all. This is the imposition of the will of Washington over all of that enormous diversity of the United States. And of course, it's then argued that this is a demographically narrow group and elite, and it's another reason for people to hate Washington. So it's very controversial in that people in Texas, if you look at the flag burning cases, US versus Eichmann and Johnson, you'll see the imposition of the Supreme Court telling people in Texas what they can and can't do. And in this case, they are allowed to burn their flags, even if the local legislature doesn't want them to. And of course, gay marriage is of course a very, very good example of that as well. We're seeing the Supreme Court establishing a one-size-fits-all policy across the states. No matter what they might want to do in Texas and Arizona, they must follow the judgment on gay marriage. That's Obergefell, and that is, it's perceived to be anti-federal. The federalism is that key idea that underlines almost everything in the Constitution, that states should be able to establish what states want to do. But we'll see lots of examples, lots of evidence where that is obviously brought to question. Finally, it's political, in that judicial review inevitably drags the court into politics. And I'm going to explore that in a little more detail in the next couple of slides, so I'm not going to drag on about that right now. But I will say that the more political the court, the more dubious it becomes as the arbiter of constitutionality. And the court at the moment, well, arguably the court at any time, is very, very political. But we can certainly see that with these four cases. We're going to talk about these an awful lot. And these are to do with campaign finance. And you see the dates there. And hopefully, from the previous presentation, you'll remember there's a cutoff here in 2005. In 2005, the balance of the court shifted, and we can see that elegantly demonstrated in the process of these cases on campaign finance. Each one of these, post-McConnell, sees the Bipartisan Campaign Reform Act of 2002 being dismantled. It was upheld in McConnell. Davis chipped away at it. Citizens United had another go at it. And then McCutcheon finally took away whatever was left. So we see a political series of decisions there. But again, we'll discuss those in much more detail as we go on. And of course, the more political the court, the more significant the role of any swing justice, which brings us to the simple observation that Kennedy is the most important man in America. Right, hearing a case. Read that. It's not very interesting. But these are the areas in which the Supreme Court has original jurisdiction. Now, that means that any case involving the Constitution itself, foreign ambassadors and diplomats, disputes between states, blah, 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 and disputes between in which one party is the U.S. government, these cases will necessarily go straight to the Supreme Court. In these areas in which the court has original jurisdiction, and they're all designed there, any case involving an issue raised thus will go straight to the Supreme Court. Now, that might not seem particularly interesting to you, but it is very, very important when we come to look at what we call appellate cases. Most of the cases that the Supreme Court looks at are appellate cases or appeal cases, and these are cases that percolate up through the system, and they're deemed worthy of the Supreme Court's time and attention. There will be about 7,000 cases every year presented to the court, of which the court will hear 3 to 4, so that's 21 or whatever it is. So the court hears very, very few cases, but the majority of those are these appellate cases that rise up through the system. And in these particular instances, the court is said to have decided that this particular issue demands certiorari, that is, making sure. In other words, we're not entirely sure what the issue is, but we need to make this certain. Now, this is so important. Previously, I don't think the significance of this was entirely clear, certainly not to me, but it's all about this issue of law and politics. Now, remember, these are cases that have percolated up through the system. If something has percolated up through the huge pyramid of the legal system of the United States, so in other words, it's gone there, and it's come out of there, and it's been appealed, and it's gone out of there, and it's been appealed, and it's gone out of there, and it's been appealed, and it's got to the top here, it's got to the Supreme Court. This is not a question of law or constitutionality. This is a question of opinion. If it's gone all the way through this system, then what we are debating is not the constitutionality of a particular issue, but but rather whether or not it is right or wrong. No matter how it might be dressed up, if a question gets to the Supreme Court through the appellate mechanism, it is a political question. Now, before the court actually sees a case, it's another political issue. Do they want to see it? At least 4 of the 9 must agree that a case deserves certiorari before they proceed. And this is not an exhaustive list of questions, but these are very typical of the questions that they will actually ask. And again, what are we seeing here? It's all about opinion. How important is it? Is this a big issue? Is it a big issue of opinion? Opinion, not fact, but opinion. Again, all this really does is that it is about establishing these are not questions of jurisprudential fact. These are questions of opinion, which leads us to critical point number 2. The Supreme Court is asked political questions. Now, let's do a little bit of deductive work here. Is the Supreme Court a judicial or a political body? Well, we've got 2 critical observations. The first is that appointments are political. The second is that questions are political, which leads us to the conclusion, of course it's bloody political. If you've got a body, the membership of which is appointed on political grounds, and you then ask it political questions, of course it's going to come back at you with political answers. It likes to dress it up in a way that suggests that it is legal, and that brings us to how we approach the Constitution. And there are 3 ways of doing that: strict constructionalist, originalist, or loose constructionist. Well, I'm getting ahead of myself. I'm going to save that for the next presentation. But when it comes to making a decision, it's a simple majority, which means that most of the ones we've been looking at so far are 5-4. All opinions are delivered in writing. There's a majority opinion, and there may well be a dissenting opinion or a concurring opinion. These are written by individual justices. Scalia writes, everyone's very impressed by him. Kagan is developing a bit of a fan base, but that's it. So it's a majority decision. Most of the contentious ones we've been looking at recently are 5-4, and of course that one is Kennedy. There will be a majority opinion. There may well be concurring and dissenting opinions, but it's the majority one that we're really interested in. And in making a decision, the following things are considered: Constitution, precedent, representation, that's your amicus curiae. The Solicitor General may make an appearance. The judge's own beliefs are going to be relevant. Public mood may very well be relevant. But the critical idea here is the independence of the judiciary. Nobody can interfere with the process of the decision making. There's enough of a mess going on there already. You can't interfere with the independence. The judges have to make up their own mind, but they will take all of these various factors into account. However, once that decision is made, there are no comebacks and no returns. 13 minutes again. Next up, we're going to actually look at how they dress up those political decisions to make them look like legal decisions. That's fun. There's all sorts of subterfuge and pretense going on, and I really look forward to discussing that with you next lesson. And I'll see you there. Cheers now.